Subscribe to get contents via mail. Purchase shorthand journals and more.
The locals working in the vicinity of the liquor factory heard some commotion coming from the liquor factory. After some time, the locals saw the deceased coming out of the factory with burn injuries on his body. One of the prosecution witnesses, PW2, who was present in the nearby agricultural field, inquired with the deceased as to what had happened. At that point of time, the deceased is said to have informed the PW2 that the accused persons had poured hot lali, raw material used for preparing local liquor, on his body, as a result of which he had suffered burn injuries. Saying so, the deceased left, and thereafter his body was recovered from the drain of tea estate. During the course of investigation, the investigating agency arrested 3 accused persons. On completion of the investigation, charge sheet was filed against all the 3 accused for the offence of murder. As the offence was exclusively triable by the Sessions Court, the magistrate in whose court the charge sheet was filed committed the case to the Court of the Sessions Judge under Section 209 of the Code of Criminal Procedure 1973. The trial court proceeded to frame charge against all the 3 accused persons for the offence punishable under Section 302 read with Section 34 of the IPC. White order dated 11/9/2008. It appears from the materials on record that the prosecution in all examined 8 witnesses. At the end of the trial court held the appellant guilty of the offence of murder of the deceased and sentenced them undergo life imprisonment with fine of ₹2,000 each. As noted above, the 3rd accused came to be acquitted. The appellant herein, being dissatisfied with the judgment and order of conviction passed by the trial court, preferred the criminal appeal number 86 of 2010 in the Gauhati High Court. The co-accused also preferred an appeal which was registered as the criminal appeal number 87 of 2010. Both the appeals were heard together and by a common judgment dated 2012-2013, both were ordered to be dismissed. Having heard the learned counsel appearing for the appellant and having gone through materials on record, the only question that falls for our consideration is whether the High Court committed any error in dismissing the criminal appeal filed by the appellant herein against the judgment and order of conviction passed by the trial court. We must first look into the medical evidence on record. The prosecution has examined Dr. N. Dihingia, PW9, as one of its witnesses to prove the post-mortem report of the deceased. Dr. Dihingia, at the relevant point of time, was serving as the senior medical and health officer at the civil hospital. In his examination in chief, he has deposed that the dead body of one deceased aged 36 years was brought at the hospital for the purpose of post-mortem.